the 2013 Spring Roundup, Amy Iverson and Darcy Reum, Estate and Business Transaction Planning.
Estate planning and the taxes and the updates. As most of you know, the American Tax Relief Act of 2012 was passed in January 1st, 2013 of this year. Included in this act was a lot of rules related to, I shouldn't say a lot, they actually dealt with some of the estate tax issues in this act. They did make it permanent, which basically means it'll take an act of Congress for it to change. And just in case you're wondering, because I was kind of curious this morning, so I Googled it. There has been over 40 tax acts since 2020. Or 2020, my bad, 2000. Sorry. So when we say it's permanent and it'll take an act of Congress, don't get too excited that it's going to be here forever and it's never going to change again. I don't have any insight, I don't have any clues, I'm just giving you a history of, in the last 12 years, there's been over 40 different tax acts. Now, have they all dealt with estate tax? No, but they've dealt with some sort of the tax code.
Just for a little background, prior to 2000, when they started messing with the estate tax on a pretty regular basis, it had stayed the same since, I believe, 1976 on the exemption amount. So it's become a trend, but they do have a history of leaving it for a long time in the past.
Okay, so in the act, what they did is they made the 5 million annual exclusions, the estate totaling less than 5 million is excluded from the tax, estate tax, meaning that if the decedent died and his estate was less than 5 million, you're not subject to the 40% that they also made permanent in the act. Additionally, the act also made permanent the portability between spouses. The portability is the ability for a family to transfer if the one spouse dies and he did not use up his exclusion, that it transfers to the spouse and she can use part of his exclusion amount. And also it made it, and I think I already mentioned this, it was 40%. So any of the amount over the 5 million is subject to a 40% tax. I can't see that. Thanks. All right, and also it also extended the deduction for state death tax credit and deduction. It extended that for the federal. So you get that deduction on your federal estate tax return, that whatever you paid for your state.
I was doing a little bit of research last night because I'm fairly familiar with Montana laws, but not Wyoming. So I was looking into it, and I believe that Wyoming is coupled with the federal estate tax. So when they reinstated that credit or deduction for the state death tax, it basically reinstated a Wyoming state death tax equal to that credit. So I think that'll impact you guys here too, where over the last few years where we haven't had that federal state death tax credit or deduction, it essentially had removed a death tax for your state as well.
All right, so along with that, the Act also extended a number of provisions that affected the qualified conservation easements, the qualified family-owned business, installment payments on estate taxes for closely held businesses, and it also repealed the 5% surtaxes on estates totaling over 10 million. It provided for the unified estate and gift tax exemption and the generation skipping tax. They're all at the 40% and the 5 million exclusion. In 2013, did I go different? Oh, in 2013, your annual exclusion gifting amount is $14,000 for the limit?
Each person can gift up to $14,000 a year with no reporting requirement or any tax or reporting requirement at all. If you gift over $14,000, then you need to file a gift tax return. That doesn't mean you're going to owe a tax at that point, but you need to file a gift tax return. At that point, you are now starting to use up some of your $5 million lifetime gift exclusion amount. And so you're not going to actually owe a tax, but you're eating away at that exclusion amount that's available for your estate essentially when you die. Or if you go over that within your lifetime, at that point you would pay a gift tax.
And then the recipient pays taxes on it?
No, it's not income to the recipient. The recipient has no reporting requirement of that gift at all. It's the giftor that needs to report. No, still the recipient does not report the gift.
If like the parents give the child, each parent can give 14
Yes.
to the child, and the child doesn't have to report that, 28.
Exactly. And if the child's married, then they can gift to the child and to the child's spouse, and you can get quite a bit of money moved in at a time.
If it's a partnership, and you're not the sole proprietor of the property, can each partner gift that much? Or is it the estate that would give that much?
A partnership doesn't make gifts. Entities do not make gifts. Individuals make gifts. So individuals make gifts. Entities do not make gifts. So if you're gifting assets owned by the partnership, essentially those are draws to the partners and gifts made by the individuals. And so then each individual can gift the $14,000. But that's really important to remember. With a partnership, it's fairly easy because partners can take draws fairly fluidly. But if you're in a corporate setting or a setting that it's more difficult, which typically would be a corporation, sometimes a trust, you have to be really careful about, because entities do not make gifts, only individuals do. So if you have an asset owned within a corporation and you want to make that gift, you need to either consider, should you be gifting corporate stock so they get ownership in the corporation, or you need to take that out of the corporation in order to make the gift, which could generate a tax at the corporate level, an income tax problem as well.
Can a trust make a gift?
A trust cannot make a gift, but depending on the nature of the trust, like on a revocable living trust, you can remove things from the trust even more fluidly than a partnership. So there's no problem that. But if you're in an irrevocable trust type setup, it really goes to the trust documents and what the provisions of the trust allow for the trustee to distribute property out. That's the determining factor on if a trust can make a gift.
Does it have to be a cash gift?
No.
It can be an asset.
Yeah.
Most of us are cash poor and asset rich.
Yes. And that's very common, but it is important to realize that the gift is valued at fair market value at the time of the gift when you do that. So if you're gifting land, it's not your basis, what you paid for it 40 years ago, that determines how much of a gift you made. It's the fair market value at the time you give the gift.
How does it assess that?
Well, there's different criteria the IRS requires to substantiate the value for a gift. Typically, you want something like an appraisal. If it's going to be a substantial gift of land or something, you're going to want an appraisal. If you're gifting livestock or equipment or something of that nature, you're going to want some sort of unrelated third party that would be considered an expert in the industry, whether it's a dealer or a livestock buyer or somebody that can give you a value.
If you get just one appraiser, they see it within the realm of possibility that that's true, that's good enough for them. Is that what they do?
There's not a distinguished requirement that says you need to have multiple appraisals. However, if you're giving a substantial gift and there's any sort of question on that value, it's not a bad idea to have more than one. It really depends on the size of the gift and how close you might be up against limits. But if you're trying to gift $5 million in land right now and you're going to use up your entire thing, you probably want to consider getting a couple of appraisals to make sure that you're not going to cause a problem. It usually doesn't cause a problem in your lifetime. It's for your estate.
Why don't you explain what basis means for everything?
Okay. And that's good because we don't actually have that in our slides, but it is a very important thing to discuss. And we'll talk a little bit as we go in as far as, you can go ahead, when we get into estate planning, and that when we talk about whether you should transfer things in your lifetime or upon death, basis is one of the major considerations. And so we'll talk more about it as we get to that point. But just for a basic how to get started when you start thinking about estate planning, because obviously you never know when you're going to die. So this isn't something you wait around to do. As soon as you have something to lose, essentially, I think you should consider having an estate plan. Because the minute there's enough there that you don't want to see it just gone, you need to be proactive and take care of things and have things in order to make sure that your heirs aren't going to be dealing with a big mess and potentially lose what you wanted them to have. So one thing that is really important to consider, I mean, we have a $5 million estate tax limit, and that's portability between spouses. So there's a whole lot of farms and ranches that are never going to actually be subject to estate tax, especially when you consider there's different discounts allowed. If it's inside a corporation, especially, you know, if there's a restrictive stock agreement on that corporation as well. If there's co-ownership of the land, all of those things, there's discounts that allow you to take that value down. So there's not a lot of family farms and ranches that are truly paying estate tax when we get these higher limits. But there still is a lot of different questions to ask beyond just the estate tax question. There's, what is your goal? What are you really wanting? Do you want to just have, you know, it go somewhere when you die? Or do you want to see the operation continue and have the next generation be able to thrive and succeed in that operation? And that's really important to think about. You know, what are you trying to go, and do you want it to be a continuing operation, or do you just want your assets distributed out after your death? The starting points, what do you got? What's it worth? Who should get it, and when should they get it? Those are the first questions that you really need to sit down. And I know that sounds really simple when you just say it on paper. Obviously, those are pretty big decisions when you actually start to think about the answers. But that's really, those are the questions that you need to be asking as you're getting started. And then after you get those questions answered, communication. You need to sit down and decide who needs to know and when should they know it. And it doesn't matter how good of an estate plan you have, there can still be a lot of money lost by not communicating it to the right people. Because even if you've done everything and you have it very solid where it can hold up to any legal challenge, a legal challenge still costs a lot of money to get through it. And if people don't know what your estate plan is, and they're not happy with it when they find out what it is after you're gone, there will be a lot of resources wasted through that process if you never tell anybody what you've planned and why.
I think a really good example of this would be, I don't know about you guys, but my dad's not a big talker. He's just, if he says good morning, it's a good day. So I don't understand his motives, and I never understood his motives of what he did for why he did it. But if you're planning on passing down your farm or ranch to your children or to somebody, you need to have that conversation with them. And maybe if you're excluding one of your other children, but you're giving them something else, have the conversation with them. It's uncomfortable and it's awful, but it's better than you dying and all of a sudden there's a legal suit that what you happened is not going to happen. So that's where the communication is important.
Yeah, I mean, we have the ranch that borders us. The family has been fighting for almost 2 years, and I don't know how many thousands of dollars have gone. Nobody's going to get nearly as much by the time the lawyers get it all. It's pretty sad. So the first questions when you ask, what do you got? And who wants to know? Who needs to know? I mean, when you're starting this estate plan, and you start doing the appraisals and compiling everything and figuring out what you have, who really needs to know? And there's a lot of different tools, so to speak. You know, you have your accountant, your lawyer, An insurance agent often is involved in estate planning. Maybe your banker, depending on your situation there. Maybe you have an investment broker or somebody else that helps you with some of your other investments. You probably need to really get all of your key players to sit down and look at the big picture, because we do somebody's tax return. A lot of times we don't have a real clear picture of what all they truly have that would be included in their estate. Why do you have to know? Well, the first question is, how much money do you need to spend on doing an estate plan? Are you going to have a taxable estate or not? How complicated of an estate plan is it going to take to get you to where you want to go with your goals? And then that kind of goes into why is it important? And who owns it now? It is amazing how many times people will sit down to do their estate plan and find out the whole place, their land, isn't owned, entitled the way they thought it was. Because there's very critical questions on who owns it now. Is it joint tenancy with right of survivorship? Is it tenants in common? Is it owned by an entity? Is it owned, individually? Who owns the assets and how it's titled is critical in determining the estate plan. And again, how complicated of an estate plan you need. And it's very often not what you think. Yeah. It definitely comes into play, because sometimes you find that everybody's on board. You want to do the succession plan, but you want to do it over time. And the bank is going to be the one that holds the trigger on if that can happen or not. What is it worth? We talked about appraisals. If you have a corporation or an entity, you might need a full-on business valuation, especially if you're doing gifts of a continuing operation. And I'm not one, Amy's not one, but we do have people in our firm that are actually certified valuation analysts, and it's a whole nother profession where things get factored in, like the ongoing business and continuing operation, as well as not just the appraisals of the assets that come into play. And when you're doing especially a structured gifting of stock, you generally will need to get a business valuation done periodically. You don't have to get a new valuation done every year, but you need to have some good substantiation, especially if you're doing annual exclusion gifts on an ongoing basis of corporate stock. This is something run into more often than not. They're ready to give the place away or figure out what they're going to do with the place. They might gift all it away, but they have mineral rights they're going to keep, or bank stock, or some other asset that you need to make sure you consider everything you own that would be included in your estate when you start this process. I know your farmers, your ranchers, it seems like that's the main asset you have, but you inherited this stock back when your dad died years ago. You kind of forgot about it, and now all of a sudden you find out that stock's worth quite a bit of money, and that's sitting in there as well. So you need to really make sure that you gather up everything. Find all of your life insurance policies. See how the life insurance is owned, entitled as well. Who owns the life insurance, and how that is where it can determine if that life insurance is included in your estate or not included in your estate upon death too. And that's a biggie that people forget about. And then, why is it important? We get into the basis issues. There's a step up in basis for anything that's included in your estate upon death that goes through your estate that would be reported on an estate tax return if one was due. It's really important to distinguish gifts in lifetime, the giver's basis, whatever they had for a basis, whether they inherited it or purchased it or whatever their existing basis is. Typically, basis is what you paid for it, less depreciation you've taken. Land is not depreciable, so it would generally be what you paid for it. Now, if great-great-grandma bought the land back in 1905, or maybe homesteaded it or something, there's very little basis unless that's passed through an estate ever. If it's been gifted over the years, when you gift, the person that receives the gift acquires the basis of the person that gave the gift. Whatever their basis was is now the basis of the person that received it. When it passes through an estate, the basis becomes the fair market value at the date of death, or an alternate valuation date 6 months later if you make that election. So what that means is now you bought land for $100 an acre, and at the time of your death, it's worth $1,000 an acre. That passes through the estate. It gets the step up in basis. Now the person that received it through the estate has the $1,000 an acre basis.
And the land itself is not depreciable, it's the improvements on it that depreciate.
Yes. Yeah, buildings, if there are farm buildings, and that would be depreciated, fences, equipment, livestock, breeding livestock, all of those things are all factors that get a step up in basis. A common thing that people forget about is the growing crop or the calves on the ground at the date of death also get a step up in basis, even though those are typically inventory without basis. They get a step up in basis to the fair market value at the date of death as well.
Then the person that receives that estate, they set up a new depreciation plan.
Yep, and they get to start depreciating things all over to the fair market value. It doesn't matter. Every piece of equipment on the place was depreciated at the date of death. It all gets to start getting depreciated back again from the fair market value at that point if it passes through the estate.
Is that true also when, say, the estate changes from, let's say, a partnership to a corporation? Is a reevaluation of the basis established then also, even though it's the same ownership?
Okay, now just a second. You said like kind of three things in there. There was an estate transfer, there was a partnership to a corporation transfer. Now, when a partnership goes into a corporation, the corporation acquires the basis that the partnership had. If you do a 351 exchange, which is the most common way of incorporating on a tax-free basis. So if you've incorporated on a tax-free thing, there's no step up in basis. Now, if at the date of death, the assets are owned inside the corporation, the corporate stock gets a step up in basis, but the underlying assets do not. And there's a big distinction between if the land is in a corporation, which we typically don't recommend putting land in a corporation, but if it's already there, that land is not getting a step up in basis at death. The corporate stock is what the individual owns that would get a step up in basis. And so now you're in a situation where you have stock basis, but if you're trying to sell the land inside the corporation, there's no step up in basis on that underlying sale of the land, and the corporation is going to owe tax on that gain.
Can you go back over that? When you said if that land was gifted, you don't get the same basis.
Right.
So,
Unless you pay a gift tax on it.
what's that?
If you pay a gift tax on it, if it's a taxable gift, you acquire basis to the extent that tax was paid on it.
If I bought land for $100 an acre, I gifted it to somebody, their basis is $100.
Exactly.
But they still pay tax on the real value? Or I pay tax on the real value?
I'm not sure what tax you're talking about.
Well, before you said when you gift something, it's the value is current market value.
Yes, that's the value of the gift for gift tax purposes.
But just for gift tax, but for everything else, the basis, if I bought it for $100 an acre, they get their basis of $100 an acre.
Right, unless it was a taxable gift. If it's a taxable gift and you pay the gift tax on it, you pay that 40% gift tax when you gift that, they get the step up in basis to the extent you paid the gift tax on that value. So if you valued it at $1,000 an acre and paid the gift tax on that $900 gain there, their basis is $1,000 if it was a taxable gift. I honestly have never seen anybody make a taxable gift. I have one client that I expect is going to, they used up their $5 million exclusion last year. They're going to start making taxable gifts this year, but I expect that's probably going to be about the only taxable gifts I see for a while.
They used up their $5 million. I take it they're still alive if they're making taxes.
Yes.
How'd they do that?
They use their $5 million gift exclusion.
Oh,
So now any gifts they make over the annual exclusion amounts will start being taxable gifts.
So they gave away $14,000 a year?
No, the 14,000 doesn't even count. They gave away, over the years, they have stock that's worth oodles, and they've gifted stock to the point of utilizing their $5 million gift.
And they did that tax-free?
Yeah, up to this point, it's been tax-free. Now, when they gift over the 14,000 exclusion, their gifts are going to be subject to the gift tax.
Is the 5 million index for inflation?
Yes, it is now.
We had double digits, going to follow with that.
Yes, now, that's brand new with this new act that they passed January 1st. They've now indexed that for inflation. So it actually ends up being about 5.12 million to be completely.
10 million is due. 10 million on state taxes, that's an index inflation.
Well, the 10 million, now be careful getting too excited about the 10 million, because the 10 million is the portability. So when the first spouse to die passes away, they have the 5 million, whatever is indexed to inflation at that point in time. And then whatever they don't use, you do have to file a 706. That's the estate tax form. Even if there's not a taxable estate, you have to file that estate tax return and check the box to make the election to save that portability for the second to die spouse for that unused exclusion amount of that estate. That's not going to go up over the years. That's locked at whatever that unused exclusion was at the time the first spouse died.
But the other ones will go up.
Yep.
Surviving spouse is what
Yeah.
inflation.
Yeah.
Have you seen anybody try selling basically selling the farm or the ranch to the next generation and then have the payment be the gift for the in intervening years?
You can do that, but you're kind of defeating a lot of things when you do that. Sorry, but when you do that, it's considered an installment sale when you're doing that. Once you've entered into an installment sale, you've locked the tax is going to be paid. Installment sale, automatically at the time you enter into the installment sale, somebody's going to pay the tax on that sale over time, but it's still going to get paid. There's not going to be a step up in basis on the land that's been sold on an installment sale. So you can, there is not a step up in basis. Once it's been sold, whatever that sales price was becomes the basis of the buyer, and the gain is going to be paid. Like I say, even over time, if the installment contract goes past death, the heirs are going to be subject to the existing gain on that installment sale. You can specifically allocate it in the will that you, like, you know, if you have 4 kids and you want the one that is buying the land, that you can allocate that gain to that heir, but the tax is going to be paid by somebody. And we see that a lot. People will do like an installment sale with a self-canceling note so they can forgive it on death, but they're still going to be tax due on that.
If my ranch is worth $10 million, and I put an undivided half in my wife's trust, and an undivided half in my trust, do we then have the $10 million?
If you do it into a trust, and depending on how you did the trust, you might not even have to worry about the $10 million. Because, yeah, because if you can pass things into a trust without ever going into the estate, and then the rules of the trust, as long as you've properly funded the trust and put the assets into the trust, it can avoid the whole estate tax question. Depending on how it's structured on that.
So the basis is the trust survives the death of the original trust, the original people that formed the trust. The trust is still the holder of the original death. The trust survives. Yeah.
But I think on a general answer, yes, you can get to the 10 million with that. But you still would need to file the 706 or you don't have 10 million.
We do a lot of estate planning, and all of a sudden, like we're seeing LLCs coming into play. So you put that LLC inside of the trust, or why is the purpose of the LLC setting something?
An LLC is a legal entity. It's actually a disregarded entity for tax purposes in a lot of ways. It's typically done for liability purposes. You may put it in the trust if you're doing it for estate purposes.
So if he wants to take that $5 million out of the trust, what effect does that have?
Depends on what kind of trust he set up and what the trust documents say. If you've created a revocable trust, you can't necessarily just take it out. It really comes to what the trust says you can do with the corpus of the trust as far as distributions of the principal of what's in that trust. If it's as far as if you have a revocable living trust that becomes irrevocable upon death, which is something we see fairly commonly, those are pretty fluid. In lifetime, you can take things in and out, but it does have to be in the trust at death to be considered part of the trust on your death. But it really comes down to the legal trust documents as far as what you can put in and out of the trust. Who should get it? When you look at things, there's a lot of questions on allocation of the assets among your heirs. Who should get the land? Who should get the operation? Do they need to be the same person? A lot of times we'll see where we have one kid that's been on the place and running it. There's other kids off the place. As you said, you don't have any cash. You've got land. And there's emotional ties in that sometimes they want the other kids that aren't there to still have a piece of land that they can come home to or something. There's different options if you're considering something like that to still allow that child that's on the place there to be able to make a go of it, because they need all of the land for the operation typically. You can do things like have a long-term lease on that land that's going to go to the off the place heirs. You can have a 20-year lease in place that survives through those leases, and then when they inherit it, it's already encumbered by that lease, so that they can't just kick off the one that's there running the place from having the utilization of that land. Yeah, it'll cost them some lease expenses, but it's already locked in. They can't jack the lease or anything like that on them either. There's different considerations about how to include on the farm ranch heirs and off the place people too. Do you have non-farmer ranch assets? Do you have something else? Do you have a life insurance policy? Does the life insurance policy need to go to the heirs that are on the place to pay down the debt? Or can the place sustain itself on a cash flow basis if the off the place heirs maybe got the life insurance proceeds, or maybe you have mineral rights or stocks or some other investments that can go there and leave the place intact? One of the biggest questions is what's fair and what's equal. And those are some of the hardest questions to answer when you sit down to do an estate plan and you have more than one potential heir. And there's nothing sadder than seeing somebody work their whole life on a place, only to have to lose it and have it go under because they have to buy out all of their siblings at fair market value after mom and dad pass away. And everybody has a story they know of, or they've lived through it with their own family of something like that, where a place got sold because everybody got along while mom and dad were alive. They pass away. Oh, I never, everybody's rich in farming and ranching, right? You don't need it. You can buy me out at fair market value. I deserve that. And some places can support that, and it can go through and work out fine, and the place can continue. But it's really tough in agriculture at the prices of land when it's valued at the most profitable use values to really be able to sustain and go on paying those kind of land prices and be able to make it truly in agriculture. And so, question, should the ownership transfer while you are alive, or should you wait for death? It's a big question. There's advantages to both ways. If you gift it while you're alive, you remove it from the estate, you remove the appreciation from the estate. Any increases in land after that point, when you gift it, that's not your problem anymore. You also, depending on the situation, if you end up in a nursing home, you might gift it while you're alive, so it's not subject to the Medicaid rules, and that you can kick in for Medicaid, so you don't lose it all for the nursing home costs. There's a lot of different considerations to whatever you decide. If you decide to gift while you're alive versus if you decide to wait until after death to transfer ownership, you also have to remember you have that until death. And so if you end up in a nursing home, I really recommend, if you have anything to lose, you probably should have some long-term care insurance or some sort of assets to offset, to provide for what you don't know could happen towards the end of your death. You don't want to work your whole life to put something together just to have it all gone right at the end. Reasons to gift while alive. You get also, you have the satisfaction. You get to see the next generation and you have that pride, you were able to turn that over to your kids and you can enjoy that. It provides motivation. I'm sure we all know stories where somebody, they work till they're 20 or 30 years on the place. They don't feel like they have anything there. All the kids left. They went and created lives for themselves. Now you don't really have anybody there that's working, that knows that operation, that can really realistically successfully just step in and know what to do to keep that operation running successfully, and maybe doesn't even want it, and the place will just end up sold. The risks of gifting while you're alive. You give up the future income, and that's one of the biggest considerations that you have to keep in mind. When you're doing your estate plan, you have to have an idea of what you're going to need to live on up until your death. And you need to make sure that your estate plan includes some sort of retained income stream to provide for that. You don't see very many people, especially in agriculture, that really want to have to go ask their kids for an allowance because they want to go buy something after they gave the kid the place. Someone else owns it and controls it. They might make stupid decisions. You don't know what they're going to do, and you can't really stop them after you gave it to them. What if something goes wrong? Maybe they made good decisions, but gosh, you guys have been hit by drought. It could get worse. If to just watch, you try to set your kid up to succeed, and to have to watch things go under over no fault of their own is tougher for a lot of parents than if it was even themselves going through it. And then there's other options besides just gifting or waiting it till you die. There's trust, there's restrictive entities. You can put it into a family limited partnership. You can put it into a corporation and bring the next generation in as owners of stock in the corporation, and you can have dual ownership. It doesn't have to be all or nothing. You can gift part of it. You can retain ownership of part of it. There's a lot of different options. You can gift the operation to the kids. Set them up with the livestock, and they run the cattle, own the equipment. You retain the land maybe until death, and they lease it from you in some fashion.
But you're still limited to that gift amount per year.
If you don't want to file a gift tax return. Yeah. The $14,000 is the annual. And if you want to be able to transfer forethought, it takes quite a few years to gift a place away at $14,000 or $28,000 a year. So if you start on a structured plan over time where you're doing that every year and not waiting until, oh no, now I need to do something, and you haven't been doing anything and you've let that go unused for 30 years, it's a lot tougher to get very many assets moved. Family limited partnerships they've been around for a long time. They can be a fairly simple in the scheme of estate planning options to transfer on an annual exclusion basis. The parents start out as the general partners, the kids start out as the limited partners. Over time, they gift those general partnership interests to where eventually the children are the general partners, and they can essentially dissolve the partnership at that time even. The communication, we talked about it. you know, it's difficult. It's probably the most difficult things you'll ever see is to have somebody sit down and talk about estate planning. It's not a fun subject. It's not a fun subject to think about on any level. But it's an important conversation to have. And I've been pretty fortunate this last year when we didn't know what the estate tax was going to be. There were a lot of people that got motivated to do things, I guess, for lack of a better way to put it. We got to be involved in some conversations. And every one of those meetings that we sat down with, it was really eye-opening how the other side, whichever structure it was, whether it was kids and parents or anything, what they thought going into the meeting was way different than what they thought going out of the meeting. They each had preconceived ideas of what they thought the other one wanted to accomplish or was thinking or wanted to do, or what their motivations were, that were completely off base. Because everybody sits around and thinks, oh, Dad just doesn't want to give up control, and Dad thinks, I just don't want to be a burden on the kids. And they never really realize that. And it's pretty powerful to get to see a family go through that, and it usually brings them a lot closer by the end.
Typically, when you start this estate planning nonsense, not nonsense, but
Yeah.
I can see this taking a long time. I mean, this isn't something you're going to settle in one meeting.
No, it's not a one meeting thing. As far as how long it takes, it varies with every individual personality that you're dealing with and how much there is to deal with. There's a lot of decisions that need to be made, and that's probably the most determining factor of how long it takes. I mean, because it takes some time to get an appraiser and get, appraisals done in that. But the determining factor is how long does it take you to decide what you really want out of it? What is your true goal? How do you want this to end up when it's all said and done? Any other questions? We'll go ahead and just go over some real life examples and what happened and what could have happened if they'd done things differently.
Okay, so just to give you a little background of, most of you can read that, but we'll give you a narrative anyway. What happens if you die without a will? So we has a husband and wife. We have 2 adult children. One son, Bob, has a wife and a stepchild who lives on the ranch. Also has a biological child from a prior relationship that has never lived on the ranch, and also has chronic health issues. All right, son 2, Jim. Jim is divorced and has 2 minor children that live on the ranch with him part-time. Husband and wife die within 6 months of each other, and both have wills leaving half of their farm and ranch to the sons. Bob dies shortly after inheriting half of the land and operation, and Bob has no will. Who gets Bob's half of the ranch? The spouse gets half of Bob's estate, the biological child gets half of Bob's estate, and the stepchild gets nothing.
If it was Montana, the spouse would have got the first $100,000 plus half of the remainder, and the biological child would have got the other half of the remainder. And every state has intestate rules for dying without a will, and that's what that refers to.
So, to recap, Jim now has half of the ranch. The other half is owned by his sister-in-law, who may remarry, and a biological child of his brothers that have never lived on the ranch. What if the sister-in-law or nephew wants a buyout? What if the nephew represents his mother?
And some ways that this could have been dealt with is if Bob had a will, first off, and stated where he wanted this to go. Obviously, he already was having chronic health issues before he even had anything to worry about having a will for. And that's something that is really easy to get caught, because I said as soon as you have something to lose, you should have a will. Well, he didn't have anything to lose, and by the time he had something to lose, he was already in a state where it was difficult to, go through an estate planning process because he was already sick. If there had been a buy-sell agreement in place, if this had been a formal partnership, and in the partnership agreement it had allowed for a buyout upon death of either partner, that could have solved a lot of the issues. And something, the partnership didn't have to be formed at the time Bob and Jim had it even. A partnership can be formed between husband and wife. When it was still mom and dad's, they could have had a partnership between the two of them that allowed for a buy-sell agreement on that partnership that went down then as the partnership went to Bob and Jim as well. Restrictive ownership agreements in place. You have entities. A lot of times, we see partnerships or corporate stocks, when you're first getting started with them, and it can be done later if you're already in an entity, but something to really consider is putting a restrictive stock ownership in there. Who can own stock, and what are the provisions if somebody would inherit stock that's not one of those okay owners through the restrictive stock agreement.
I have a question. If somebody is in a sole proprietorship, and say they write into the will that one person has the first right of purchase upon death, would that person get the step up in basis because it went through the estate?
Yes.
Even though they didn't purchase the land?
Yep. They have the right of refusal. It's not a purchase agreement that's binding. So they would get the step up in basis. If it said, if it was a binding purchase agreement where they couldn't back out, then it would be considered that the purchase agreement was already in existence. But as long as they have the right of refusal in there, it would get the step up in basis.
Okay, example 2. Husband and wife own half each of the ranch. They have 4 adult children. None are currently on the ranch. They had one, but they kicked him off. And the will leaves the life estate in property to survive the spouse, and the remaining quarters go to each of their children. So the husband and wife are both deceased. The ranch is owned a quarter undivided shares to each adult child. One is still mad because dad kicked him off. You never do hear his side of the story, do you? Yeah. Now they need to lease or sell the place. The angry son is digging in and stopping all progress.
And this is actually a friend of mine's got this situation going on. How do you deal with when people just don't get along and they just don't want to get along because they're mad about something that happened years ago? And there's not a lot you can do about people being mad, so you need to make sure that you have a structure in place that can allow somebody to be mad and still not hamstring everybody else's progress. An entity to manage the property. If that, instead of going a 1/4 undivided interest to each child, went to a partnership where the partnership agreement allowed any 3 partners to make a decision, they could still do a lease or sell that property or move forward in some fashion without needing to get that last holdup on board. You could have put that into a trust that could have, again, a trustee to make those decisions and keep progress moving forward. Right now, nobody's getting anything off that land. It's just sitting there vacant. You can separate out the tracts. Instead of giving a 1/4 undivided interest to each child, you actually say, you get this piece of land, you get this piece of land, you get this, and identify that in lifetime so that when it goes through the will and it gets to that point, they don't have to get along to still be able to go forward.